Hello, welcome to my podcast. I'm Emma. This is my guest, Jacob.
Hello.
Today we are discussing civil rights issues in Texas. Tell me, Jacob, what was your case and who was involved?
My case, women's health versus Jackson, was a case that involved the aforementioned parties, and it was in regards to a group of different parties trying to block the legislation known as Texas SB 8. And Texas SB 8 is in regards to reproductive rights and abortion. Specifically, it mandates that providers cannot perform abortions on individuals who are more than 6 weeks pregnant, and it also states that anyone who successfully sues a provider that has performed an abortion on a pregnancy older than 6 weeks is compensated or is liable. Can earn about $10,000 in damages. And it was mostly the whole women's health organization, asking the Supreme Court of Texas to delay voting on SB 8.
What amendment in the Constitution did you think was relevant to the issue at stake?
I believe that Amendment 14 is the most relevant amendment to not only the case of whole women's health versus Jackson, but also to the overall cases that this case helped lead to, but I can get into that later. Specifically in that it mentions in Amendment 14 that all U.S. citizens, that no rights or liberties of any U.S. citizens should be reached upon or should be undermined.
Yes. What was the outcome of your case? What was the significance of it?
So, after the case went through the Texas Supreme Court, after it went through the Texas Supreme Court, it went through the Fifth Circuit of Texas in 3 times in 3 months. And the motion was struck down every single time. And it's significant because this is the ruling against halting the voting on a bill like this meant that the bill passed through, and with the bill passing through, that reduced the number of clinics for abortion from about 10 the previous year to now only 5. And considering that there's 5.4 million women in Texas, and that most women do not know that they are pregnant before 6 weeks, that it becomes pretty significant both for those who were pregnant at the time of ruling, because you don't know if one has medical complications or what the history there is, and both for future cases. And it has the potential to affect a vast variety or a vast amount of people, and and bills like this often affect those in minority groups, either low income or racial, religious, or ethnic minorities.
That is absolutely very true.
Thank you for the questions. Actually, I have heard that you know quite a bit about women's reproductive rights, and that you have been doing a lot of research on this, including on a specific case. Would you like to answer a few questions about that?
Yeah.
So first of all, what was the name of your case and what was it about?
My case was actually Whole Women's Health v. Hellerstedt.
Interesting.
Yes, and with this case, Texas was trying to pass a law that made it so that abortion clinics had to have admitting privileges to a hospital within 30 miles, and that they had to meet the same standards as a surgical center, as an outpatient surgical center. And
what's the constitutional issue that this case is about?
This case addresses mainly the 14th Amendment, same as yours, where the 14th Amendment grants equal protection to all United States citizens under the Constitution. And in a previous case, Planned Parenthood of Southeastern Pennsylvania v. Casey, the Supreme Court actually ruled that any provision of law is constitutionally invalid if the purpose or effect of it is to place substantial obstacle in a woman's path of getting an abortion before the fetus attains viability. And it was also said that viability of a fetus means that it can survive independently outside of the woman's womb. So if the fetus can't survive on its own, it's not viable, and thus any obstacle placed in the woman's path of getting an abortion is unconstitutional.
So that leads into my next question. Who is this case mainly about?
It's mainly about women of reproductive age in Texas. And like you said earlier, there's about 5.4 million women in Texas that are of reproductive age. And this affects them mainly because requiring these admitting privileges and that clinics meet the standards of surgical centers reduces the number of clinics that are open. So before the bills in this law were put into effect, there were more than 40 clinics in all of Texas. After they went into effect, there were only 10 in the entire state. And Texas, as I'm sure you know, is the second largest state in the US.
Yes.
And so the fact that there's only 10 clinics available was a huge thing. And the American Medical Association and the American College of Obstetricians and Gynecologists agreed that the provisions of the law were not to help women. They were to prevent abortions and thus are a substantial obstacle and would be ruled as unconstitutional. And so that's why Whole Women's Health took this to the Supreme Court.
Interesting. So what was the ruling? Was it ruled as unconstitutional?
Yes, it was. The Supreme Court, and this was the federal Supreme Court, ruled 5-3 against this Texan law and had it struck down. And they did this because they found that through expert testimony that legal abortions are safe, if not safer, than
carrying to term.
Well, not in some cases, yes, but that legal abortions can be safer than outpatient medical surgeries at hospitals.
Oh yeah, I can see how that would be the case. Yes.
Yeah, they found that complications that require hospitalization are not only super rare, but also in the cases that it does happen, being your doctor having admitting privileges to the hospital doesn't improve your care. They found that there's no credible evidence to back up the claim that requiring admitting privileges enhances your physician's credibility, I guess. And they also found that admitting privileges forces clinics to close. And so because of all that, they decided that, these laws are a block to women's health and are thus unconstitutional, and so they had the law struck down.
Good to know.